Good morning, students. The topic of today's lecture is Judicial Control over Administration. It is for BA1 Semester 2 students studying Indian Administration. The lecture is by Dr. Vibha Sharma. Now let us discuss the objectives of this lecture. The main objective of this lecture is to make the students aware of rule of law, significance of judicial control, grounds of judicial review, mode of judicial review, judicial remedies available, as well as limitation of judicial control. Judicial control over administration. Judiciary also exercises control over administration besides the legislature to ensure that the governments of the day function in the manner it is required for them to function. The modern governments of today are performing a very large number of functions, so there are many chances that it ends up misusing or abusing power. Now let us understand rule of law. Rule of law is the cornerstone of modern democratic countries. It has the following principles. The supremacy of law. The first principle of rule of law signifies the predominance of regular law as opposed to prevalence of arbitrary and discretionary power. It negates the existence of arbitrariness as well as any form of sovereign prerogative. Equality before law. The second principle signifies equal subjection of all citizens, rich or poor, official, non-official, to the ordinary law of the land. Predominance of legal spirit. The third principle states that all administrative authorities in the country are subject to the jurisdiction of ordinary civil courts of the land. No person can be deprived of his life or personal liberty except as per the procedure established by law. Additionally, all rules, regulations, bylaws made by the authorities can be challenged before the court, which can declare them unconstitutional in case they violate the provisions of the Constitution. Significance of judicial control. Judicial control plays a crucial role in a democratic country in ensuring that the government does not abuse its powers. Following are the reasons why judicial control is required. Constitution is supreme. Constitution is supreme and the administrative actions can be challenged in the court of law. Legislations. Legislations that are required to deal with modern and contemporary problems may be limiting the rights of the citizens, thereby requiring judicial control. To check abuse of power. Judicial control is very essential to ensure that the governments do not misuse or abuse their powers. Increasing corruption. It is also required as nowadays corruption is high, leading to abuse of power by some. Partisan legislations. Sometimes some legislations may be made due to political considerations. Such legislations can be challenged in the court of law. Ensures rule of law. To ensure rule of law and not law of jungle, judicial control is a necessity and to guarantee the rights of the citizens. In face of partisan legislations or the government abusing its power or the government discriminating against citizens, judicial control becomes very significant. Let us now understand what is abuse of power. Abuse of power by the government or the administration is one of the biggest malady in the present times. Let us now understand what is abuse of power. Abuse of power is when a decision taken by the government is not in public interest but motivated by personal interest, or when a decision is made in hurry, not understanding the implications in full, or as well as when a decision promotes the financial interest of the agency itself. Grounds for judicial review. Following are the grounds for judicial review. Violation in the spirit of the Constitution or the Constitution itself. If any act of the administration violates the spirit of the Constitution or the Constitution itself, then it becomes a ground of judicial review. Error of fact finding. When the citizens are affected by the decisions due to errors in the fact finding or other administrative errors. Violation of law. When the decisions taken by the officer violates a rule, a law previously made. Violation of the rules of natural justice. In case the rules of natural justice, that is, adequate notice needs to be given for taking action. The first rule. Second, everyone gets a fair hearing. And third, all to be treated equally before the law, and there should not be any bias are violated, then the affected party can go to the court. Grounds for judicial review. Continues. Lack of jurisdiction. Power vested in Officer A is used by Officer B. If decision is taken by an officer who doesn't have authority to do so, then the affected party can go to the court of law. Procedural error. In this case, the officer has authority but follows a wrong procedure to take the necessary decision. Error in fact finding. An aggrieved person can approach the court of law in case the officer concerned takes a decision on account of error in the interpretation of facts. Malified decision making. In case decisions are taken with malified intentions and it adversely affects a mode of judicial review. Mode of judicial review over administration is as follows. Power of judicial review. It is a process in which the courts can give judgment upon the validity of an action taken by the executive. If on examination it is found that any administrative action is violative of the Constitution, that is ultra vires, then it can be declared as illegal, unconstitutional, and invalid by the court. Doctrine of ultra vires. This doctrine is traditionally the basis of judicial control of acts and decisions by the executive. It means any act or decision by an administrative authority is to be exercised within the limits prescribed by law. If any decision or act of the administrative is beyond the given power, then it is stated to be ultra vires and hence void ab initio. Appeals. Under the provision, an aggrieved citizen has a right to appeal to the courts against administrative acts. The statute or the law or the act may itself have such a provision. Suits against the government. As per Article 300 of the Constitution, the union government or the state governments can be sued subject to the provisions of the law made by the Parliament or the state legislatures respectively. The state is suable in contract. Judicial remedies. Writs. The term writ is defined as a formal order under a seal issued under the name of a government or a court or a competent authority directing the officer to whom it is issued to perform or not perform some specific function. As per the Article 32, Clause 2 of the Constitution, the Supreme Court shall have the power to issue directions or orders or appropriate writs for the enforcement of the rights of the citizens. That's the fundamental rights. Similar power is conferred to the High Courts under Article 226 of the Indian Constitution. Following are the different types of writs. We will discuss the writs in the next slides. Habeas corpus, mandamus, prohibition, certiorari, quo warranto, and injunction. Now let us discuss the first writ, that is the writ of habeas corpus. Habeas corpus literally means have or bring the body. This writ is an order of the court to an official or an authority who has detained a person to present him before the court. The court then decides on the validity and justification of his detention. It is a prompt and effective remedy in case of unlawful restraint or detention of a person. The object of this writ is to ensure that a person is freed and not held unlawfully by the officials or the authorities. This remedy is available against anybody. That is, even a private person, and not only against a police official who has detained another person unlawfully. Now let us discuss the second writ, that is mandamus. Mandamus literally means we command. It is an order issued by a court to a public authority which directs the public authority to perform a public duty imposed upon it by the law. It is directed to an official of the government or a subordinate court or any other public authority, calling upon it to do, that is to perform, or to refrain, that is to not do, any specific act which such an authority is under obligation to do or refrain from doing. That is, any act which the government has to do, an official has to do, the court can ask it to do if it is not doing, and any other action which the government or the official is not required to do but is doing, in that case the court can refrain that person from doing so. The object of this writ is to ensure justice in case the aggrieved party does not have any other remedy. The court has discretion to grant or refuse relief under this writ to the aggrieved party. That is, it may give the relief, it may give the writ of mandamus, or it may refuse. This discretion is required to be exercised in a fair and reasonable manner and as per law. The third writ is the writ of prohibition. The writ of prohibition is preventive relief which prevents a lower court or a tribunal or a quasi-judicial authority from exceeding its jurisdiction and thereby exercising jurisdiction which is not vested in it. It can be issued on the following grounds. It is issued in cases where the lower authority acts without jurisdiction or beyond its jurisdiction. It can be issued in case of violation of the rule of natural justice or when the stated authority infringes upon the fundamental rights of the applicant, as well as in case where the concerned authority has committed an error of law which is apparent on the record. The fourth writ is of certiorari. Certiorari is a writ in which a superior court, Supreme Court and the High Court exercise supervisory jurisdiction over their respective inferior courts, tribunals, boards or other judicial and non-judicial authorities. This writ can be issued on the following grounds. The first one being when the judicial or the quasi-judicial authority has acted without jurisdiction in excess of its jurisdiction or has failed to exercise jurisdiction vested in it by law, or when there is an apparent error of law, or when the inferior body has not complied with the rules of natural justice. Quo warranto is the fifth writ. Quo warranto means by what authority. It is a remedy directed against an incumbent of a public office. It requires a person to show under what authority he is holding such an office. It protects public interests by preventing and curing invasion or abuse of a public office by a person not qualified to hold the same. Injunction. It is issued to ask a person to do a thing or refrain from doing it. It is of mandatory and preventive type. It is primarily a process of private law and only rarely a remedy in administrative law. Writs cannot examine policy matters within its writ jurisdiction. Writs cannot be invoked to obtain relief in case of alleged violation of private rights of petitioner. Limitations of judicial control. Now let us discuss the factors that limit the effectiveness of judicial control. Judiciary cannot intervene in administrative processes on its own. The courts intervene only when the aggrieved citizen takes the matter before them. Therefore, the judiciary lacks suo motu power. The control exercised by the courts is in the nature of a post-mortem control. That is, they intervene after the damage is done to the citizen by the administrative acts. All administrative acts are not subject to judicial control, as the Parliament may exclude certain matters from the jurisdiction of the courts. Self-denying ordinance, that is, the judiciary denies to itself jurisdiction in certain matters. That is, the courts refuse to intervene in certain purely administrative matters on its own accord. And we all know the judicial process is very slow and very cumbersome. Besides, it's also very expensive. The judges, being legal experts, cannot fully and properly understand the highly technical nature of administrative acts. The volume, the variety and complexity of administration has increased due to the welfare orientation of the state. Hence, the courts cannot review each and every administrative act affecting the citizens. Dear students, hope you have understood the lecture. This lecture covered a brief introduction of the rule of law, significance of judicial control, grounds on which judiciary can review an administrative decision, different mode of judicial review, different judicial remedies available to the citizens, as well as the limitations of judicial control over administration. Thank you.